All right, everyone, welcome to this Sunday's real estate exam prep. And today, what we're going to do is we're going to go over the national portion. And as we're going through, right, we can see that the state exam, you need 53 out of 74 questions right, and you get 110 minutes to execute. And on the national piece, you need 60 out of 80. And you have 120 minutes to execute that one. And so instead of going through the entirety of the test, what we have done today is we're going to go over property ownership, valuations and market analysis, financing, general principles of agency, contracts, practice of real estate, and real estate calculations. And so if those are the only things that we focus on, and if we were to get all of those correct, we would get a 78% and not focus on any of the transfer title, the leasing, property disclosures, land use regulations. Like, we didn't touch any of that stuff. This is enough to get us a passing grade. And so the only reason to show this is you don't need to get everything correct. And the big pieces that we're going to be going through, the big pieces are what you're going to see on both sides of the exam. So let's jump into it, and let's start with property ownership. These are the pieces that you're going to see on the property ownership piece, right? We're going to go over types of legal descriptions, real versus personal property, conveyances, encumbrances and effects on property ownership, right? Liens, easements, encroachments, and then types of ownership, tenants in common and joint tenancy. So this is what you would expect to see on the national exam directly off of PSI. Like, this is directly where I've pulled this from. So as we jump into it, we have property ownership. And it says there are two types of property. We have real property and personal property. So real property is the land and anything affixed to the land, and the rights and interests in the land, where real property is conveyed by a deed. All right, so real property is conveyed by a deed. And then we have personal property, also chattel, right? So includes all items, but not limited to the land that may be conveyed when the property is sold. Each item on personal property is listed in the conveyed by a bill of sale. So, like, as we're going through this, personal property can either go with the sale or doesn't have to go with the sale, right? So if I'm saying that, like, a personal property is a refrigerator, I can take the refrigerator with me, or I can leave the refrigerator with the bill of sale with the property. So I just wanted to keep in mind that whether it's a fixture or personal property, it could be an inclusion or an exclusion. It could be either one. So we have to be able to read through the test to understand what they're asking us. And it says the rights and interests in the land include air rights, water rights, mineral rights, oil, gas rights, right? And so improvements may be natural or man-made, and these are fixtures, right? So this could be the chandelier. This could be the tree, right? This could be so many different things. Could be a fixture. And then personal property attached to the improvements become a fixture, right? So when we start thinking about this, a lot of times we start talking about the fence, right? Where we start saying we have a piece of land and we put together the lumber, we have the nails, the concrete, and it's just laying in a pile. Well, that's all personal property. And then when we turn it into a fence, right, we pour the concrete into the ground, we assemble the fence, now it's a fixture, right? So it's all determined on how it's affixed to the property. So then as we go through, right, it says the test for distinguishing fixtures and personal property are based on determining the intent of the parties. And it says the test will include the method of attachment, adaptation of the item of the property, the relationship of the parties, and any provisions in the written contract. So the provisions, right, will actually tell you what the intent is. Like the washer and dryer, they're personal property. They're not attached to anything. But the contract to buy and sell between the buyer and the seller can state that it stays with the home. And so this just matters. Like, we need to read through this to understand how they want us to treat either the fixture or the personal property. Same thing with the chandelier. The chandelier is a fixture. It doesn't mean I can't take it, right? I just have to state in the contract my intent is to take it as we're going through. All valid deeds must contain a legal description of the land being conveyed. And there are three major types, right? We go meets and bounds, rectangular survey, and lot and block. So those are the three that we're going to see. And you might see a test question, right, that says which one of these is not a valid legal description. And they're going to have property address, right? And so where it gets, I think, a little confusing is they might call it a governmental survey or they might call it a rectangular land survey. And so depending on which one they're referring to, that's the one that we need to be able to pick up on and just know that the address is garbage. And then we have the priority of liens, right? As we're going through, it says refers to who gets paid first when the property is being sold. And we know that the mortgage holds the first position unless someone defaults on taxes. Then Uncle Sam goes into the first position. And that's why we don't see a lot of, that's why we see the escrow accounts for 3-4 months, because the bank is protecting themselves. So if we stop paying taxes, that they can actually pay the taxes, start the foreclosure process, take the home, get the home sold, and so that the government can't take the house actually from the bank. And we have a voluntary lien. We know that a mortgage is a voluntary lien, and an involuntary lien, as we're going through, that's something that's placed against the owner's will. This might be a mechanic's lien, a judgment, something where the owner didn't want it, but now it's on there. A specific lien attaches to the property, and a general lien attaches to potentially a number of properties or an asset. So as we're going through, like, these are all different pieces to start with that we will see on the test. We dive into it a little bit further. We have tenancy in common. Equal or unequal ownership between two or more parties. And when one party dies, it goes to their heirs, right? This is a willable interest. And then we have joint tenancy, and the four things that we need to have interest, possession, time, and title. So all the parties need to take over the title at the exact same time. I think you might see a test question that if two joint tenants own a property and then they sell a share to a third person, what will that person hold title as? Tenants in common. So we'll have two joint tenants and one tenant in common because of this time piece right here. They didn't take over possession at the exact same time, so now they are a tenant in common. They can will their shares, whereas if the one joint tenant dies, the other one will get their share, right? So one person would go from 33 to 66%, and the tenant in common would just be able to will their 33% to whomever.
So in joint tenancy, you can't will it?
It's not willable. Nope. The right of survivorship, and that's what they're going to ask you on the test, is the right of survivorship. So then we have severalty. I need you to keep in mind that severalty can be a person or a corporation. Okay, so this can be a corporation that owns it in its entirety, and or just a single individual can own it in its entirety for severalty. Tenancy by the entirety is for married people. All right, so I want you to think of this as married couples. And it's interesting because when you look at it, it says it has aspects of survivorship attached to it. And really the aspects is just this. It's only meant for married couples so that you're not really bringing in a third party at that point. So there is no tenants in common situations in here where it's willable. It goes to the other married party once the husband or the wife passes away. We have a timeshare. And this is just for a way for people to purchase an interest in a vacation property, right? We start thinking about going up to Vail or these different places, and we have a calendar, and the calendar says how long we are allowed to stay in the property. So we have an interest in essentially a calendar to where we get to use the property for a certain amount of time. A cooperative or a co-op is a building, right, where the corporation owns it, and essentially you're getting like a stock certificate. Right? For while you're in this property, you get a percentage of how long that you are allowed to use it for. An encumbrance is a claim or other issues that burdens or restrains full ownership, right? To where you might have a mortgage. That would be an encumbrance. There might be a lien on the property. And then we have easements, right? That is the right for another party to use your land. So both of these sections, this is the meat of both your property ownership pieces. So this is 8% of your test. So then we have 10%, which is your financing. So we're going to go through, they're going to want to know, do you know about points, loan to value, PMI, interest, PITI, financing instruments, whether it's a mortgage, a promissory note. They're going to want to know the types of loan. Do you know who's going to get a conventional, FHA, VA, USDA? What's an amortized loan? What's an adjustable rate mortgage, an ARM? Bridge loans, lending process applications, financing credit laws. Do you know TILA, RESPA, equal credit, opportunity? Do you know TRID? This is what they're going to be testing you on when you get into the financing piece. So as we go through, the first thing is just mortgage points. So mortgage points are the fees a borrower pays a mortgage lender in order to trim down the interest rate. And most of the time it's 1%, right? They're going to go through and they're going to talk about a point as 1%. And the concept that you're going to have to know is it's not 1% of the purchase price. It's 1% of the loan, right? Because you're bringing down the down payment, you're bringing the earnest money, and so whatever the bank's loaning you, that's what you're going to pay the 1% on. So it's the bank's loan times 1%, or they might be 3 points or 4 points, but a point is just 1%, so it'll be 3%, 4%, whatever that looks like. Then we have loan to value ratio, and this is a ratio of a mortgage loan to the principal for a property appraised value and the sales price. And so a loan to value might be on a $100,000 property, and you have to bring 20%. So you have to bring 20%, and then the bank brings 80%. So that's an 80% loan to value of the property. All right, so you're bringing down 20,000. The bank's giving you 80,000. So the bank's loaning you 80% of the 100,000. So it's 80% loan to value. And the concept that you need to know is this: the bank is only going to loan you whatever is lower. When they're giving you the loan, they're going to loan you either the purchase price or the appraised price. Whichever one is lower, that is the loan that you're going to get. Okay, so if the purchase price is $100K, but the loan only comes in at $90,000, they're only going to loan you up to $90,000. They're not going to loan you the entire purchase price. I think you're going to see a test question around that as well. Then we have private mortgage insurance, and this would be on an FHA or a VA loan, and it is the insurance that gets put onto your loan because your loan to value is too high, okay? So that you're a risk to the lender. So what they're saying is that you've borrowed so much money and you have very little skin in the game that you need to pay insurance just in case you default, because they think that you are at risk of defaulting and you'd be okay with it because you don't have a lot of money into this. Then we have PITI, principal, interest, taxes, insurance, and they're going to call it PITI. And these are the 4 basic elements of your monthly mortgage payment. Your promissory note is the document to the lender, and it serves as just the promise. This is the promise to repay the loan on the house. And the mortgage is the collateral that you're putting up for the home.
Somebody can't find
So as you're going through, awesome. So then as we're going through, we have different loan types, right? So we have FHA loans. An FHA loan, it is a lower down payment. You still have to have good credit, And this is a loan that is backed by the government. Then we have a conventional loan, and this is a loan that is not guaranteed by the government. This is a larger down payment, and you have to have great credit. And then we have a VA loan, which is for our veterans. It is $0 down payment, no mortgage insurance, and is guaranteed by the government as well. We have a USDA loan, and these are for borrowers who aren't wealthy enough to get a traditional mortgage. We have a fully amortized loan, which just means it has a schedule, right, to where we're going to pay X amount of dollars over the next 30 years. And if you go to and have a closing, it's like a book that's like this big on how much money that you will be paying over the next 30 years. And it is twice what the home is worth. And it is very sad to get that piece of paper. We have an ARM. And this is just an interest rate that will periodically change, right? And so it will go up or down depending on what's going on in the market. So you have to think that an ARM loan would have been great like 2 years ago when we were at these low interest rates. You don't want an ARM loan right now because your mortgage is going to be significantly higher because our rates are going up. And then we have a bridge loan. And these have a high interest rate, and they are backed by some kind of collateral. So you might get a bridge loan on your current home, and you would be able to go buy another home with the loan based off of the equity that you have in your current home. So then we go through, and it says for loans covered under TILA, Truth in Lending Act, you have the right of rescission, which allows you 3 days to reconsider your decision and back out of the loan process without losing any money. And this right helps protect you against high-pressure sales tactics used by unscrupulous lenders. TILA does not tell banks how much interest they may charge you or whether they must grant you a loan. So all this is it says like, here's how much we will charge you, and if you need to back out of it because you've changed your mind and it's too expensive, you can. Then we have RESPA. The Real Estate Settlement Procedures Act provides consumers with improved disclosures of the settlement cost and to reduce the cost of closing that eliminates for the referral fees and kickbacks. So RESPA's big thing is it gets rid of kickbacks and referral fees that are undisclosed. So remember that because of RESPA, we actually have to say that yes, you're going to use my roofer, my lender, my title company, and they're going to give me money back, right? And maybe it wasn't because they were the best. It was more so because they were going to give me a kickback. So this actually lowers rates down because now you know that you were probably using this person because the real estate agent was going to be getting money from them. We have the ECOA, the Equal Credit Opportunity Act, and this is a federal civil rights law that prevents lenders from discriminating against applicants based off of factors unrelated to their ability to pay. So this goes through and this just says, look, the only thing that you are allowed to discriminate people against is if they aren't able to pay back their loan. That is it. There can be no other circumstances that you decide to deny someone a loan on. And then we have TRID, and this is the TILA-RESPA Integrated Disclosure Rule. And this dictates what mortgage information lenders need to provide borrowers and when they must provide it. And it says TRID rules also regulate what fees lenders can charge and how these fees can change as the mortgage matures. So TRID dictates how much they can charge. TILA dictates how they have to give you the protections and when they have to give you the fees associated with it. So keep in mind that TRID is the one that dictates the dollars. So HUD, when we get into this, these are some of the things that you're going to need to know as well. The HUD booklet, Buying Your Home Settlement Costs and Helpful Information, must be given to anyone applying for a mortgage. So there's this booklet that talks about all the different things that could happen in your buying process as far as the dollars, and this is a mandatory booklet that needs to be given.
What does HUD stand for?
Housing and Urban Development. And then we have the HUD-1 form. All right, so the HUD-1 form, right, this is your 6-column worksheet, right? How much the buyer's being credited, how much the seller's being credited, how much the seller's being debited, how much the buyer's being debited, as well as the titles or the title company / broker. Okay, and so on the test, they're not going to say title / broker. They're going to call it one or the other. They're going to either say the broker or the title company. They're not going to give you that /, so you're going to need to know that it's just the same one. So the HUD-1 form preparation, right, which is the settlement closing sheet, when the mortgage loan closes, which is usually at the same time the title to the property is closed, a settlement statement or closing statement of costs must be prepared. The settlement statement must be prepared on a form called the HUD-1, which is also called the HUD Uniform Settlement Statement. So just your HUD-1 is your 6-column worksheet, and it's just telling you where all the dollars are going. Prohibited kickbacks, again, RESPA prohibits kickbacks, and those are just unearned fees. And then if you see something called closing and escrow, and we don't have closing and escrow in Colorado, but it says involves using a third party, sometimes called an escrow agent, to gather all the documents necessary for closing and then forward all the papers and the money to the parties involved. So if you see escrow, just think of a title company that you're not sitting at the table together and all the monies are just going to some place, all the papers are going to some place, and then they distribute them all out. Cool. So these are the two things that I believe that you're going to see on the financing and the topics that you need to know for 10%. So this is 8 questions. General principles of agency. This is 13% of the test. So as we're going through, they want to know agency and non-agency relationships, agents' duties to their clients, the creation of agency and non-agency agreements, disclosures of conflict of interest, responsibilities of agents to consumers and third parties, including disclosures, honest integrity, and counting for money, and then your termination of agency. So these are the things that you're going to need to know to be able to get through this piece of the test. So expressed agency is where the agency relationship is created through an agreement in which the agent and the principal state their intentions to each other, right? So this is like, hey, I would like to be your real estate agent. And they're like, awesome, I would love you to be my real estate agent. Cool. Expressed agency. Implied agency establishes an agency relationship through the actions of two parties. Although nothing formal has been said or written, the agent and the principal act as if they have a relationship, right? And so this is where I'm thinking like, hey, you want to go see some open houses? And they're like, yeah, let's go look. We never said that we were going to work together, but yet I'm showing them open houses. They jumped in my car. We went and looked together. We never said we were working together, but we were doing agency stuff. So implied is through our actions, and there is nothing written or really verbal about it because we're just implying it through what we're doing. And express can either be written and or oral, and that's how we have an expressed agency. An agency coupled with interest is a situation in which the agent has some kind of interest in the property that is being sold. A special agent is granted the authority to represent a principal or client in a specific task or transaction. So I just want you to think of a regular real estate agent, right? This is someone helping you sell 123 Main Street. This is someone helping you buy a home in the Denver metro area. This is a specific task. A general agent represents the principal in a range of activities or particular business. And so I want you to think of a property manager here. This is someone that is collecting rents. They are advertising the property. They are answering the phone when something's broken at 3 a.m, right? This is a general agent, or I'm sorry, a special agent. And then a general agent represents the principal in a range of activities. That's a general agent. Or then we have the universal agent, and I want you to think of a POA. This is a power of attorney. This is someone that will be doing different things as well as potentially signing on the behalf of the client. So special agent, 123 Main Street, just a regular real estate agent. A general agent, I want you to think of a property manager. And then you have your universal agent, I want you to think of POA, power of attorney, someone that's doing real estate activities and then some things. And I think typically signing their name for the client. So then we have this for the general responsibilities of an agent. Okay, and so it is care, obedience, accounting, loyalty, and disclosure. And then we also have this other piece, which is confidentiality, right? And so I think that what we have learned in an American real estate college, right, is that AC COLD, right, would be your acronym. And so care, obedience, accounting, loyalty, disclosure, and then confidentiality. That's what you owe as an agent to your client. And it says you can authorize an attorney-in-fact or a POA for such things as signing checks and tax returns, entering into contracts, buying or selling real estate, depositing or withdrawing funds, running a business, or anything else that you do yourself. So when you have that POA, they can actually sign your name. And so as we're going through this might be someone that's making like multiple offers on properties. And they just tell their real estate agent, hey, if you come across one, here's the money. They already have the earnest money check. And they're going through and they're just writing offers for their clients. Like, that's where we would see this. The customer is the third party to the transaction. So if you as the broker are the agent for the seller is then your principal, and the buyer is the third party. And I need to hit that home because on the exam, they're going to be talking about the customer. And the customer, if you're representing the seller, is the buyer. And the customer, if you're in an open house, is the person walking in off the street, right? If you represent the seller. So you need to be able to distinguish that too. It has nothing to do with do they have an agency agreement or not. It has everything to do with who you have the agency agreement with, right? That's the only thing. So if you have an agency agreement, everyone else is a customer to you. And with that being said, you owe them honest and fair business dealings. You owe them reasonable skill and care, and you owe them disclosure to material facts that are actually known. These are the three things that you owe the buyer if you represent the seller, or the person that walks in off the street if you represent the seller. You must give them these three things. And so the reasonable skill and care dives more into, if I offer this and I do this for them, will it hurt my client? And if the answer is no, then that's where we do that. That's the reasonable skill and care. But I'm not going to do anything that would jeopardize my client or hurt my client with that piece right there. Diving into it a little bit further, we have to know contracts, right? And so these are the contracts that we're going to see. We're going to see the exclusive right to sell listing contract, the exclusive agency agreement, open listing agreement, the exclusive buyer agency agreement, and the exclusive agency buyer agency agreement. So your exclusive right to sell listing agreement has the most protections for you, the agent. And I think that's how the test question is going to look. It's going to say, which one of these contracts has the most protections for the agent? Is the exclusive right. Which means that if I put the sign in the yard and I have this agreement with my client, and they're outside talking to the neighbor, and the neighbor is like, you know what, I would love to buy your house, I still get paid. The exclusive agency agreement means no other real estate agent would get paid. And if the client goes and they're talking to that same neighbor and they put a deal together, I was not the procuring cause, I don't get paid. Open listing agreement, and there's also an open buyer agency agreement, which just means that if the client gets to work with me, another agent at another brokerage, and another brokerage. And if any of these brokerages find them either the buyer or seller, then they pay that person. And if none of us do and they find their own, they don't pay us anything. So that's an open listing. Your exclusive buyer agency has the most protections for you, again, on the buy side. And then this is the one that helps me out. When I see exclusive agency, buyer agency, they've mentioned agency twice in that sentence. That means I have to be the procuring cause. So on your test, if you see exclusive agency, buyer agency agreement, they've mentioned agency twice, that means that you have to be the procuring cause in order to get paid. So same thing, you have this agreement with someone, and it's the weekend, you're busy, maybe you're on vacation or you're doing whatever, your client goes to some open houses without you, and you were not a part of that process, they don't have to pay you anymore. They are doing a deal with the client or with the seller, and they cut you out of it. And then general principles, some more, right? So 3 slides, this is 13%. There's a lot of different pieces in here. The definitions of the working relationship, all right? What this form is this form tells the customer what you cannot offer them, right? Which essentially is like, I cannot be your agent. I can treat you as a customer, right? This is all this form is doing, is it's saying that this is all that's left. This is the only way that I can help you, because I already have an agency agreement, so I can help you off of this right here, which just means like if you're an agent, I can treat you as a customer, which means I owe you those 3 pieces, the fair and honest dealings, disclosure of material facts, and care. I cannot give you anything else. I can't give you advice. I can't know your motivations, and we need to give this form as soon as possible, right, in a timely manner, because if someone starts telling me their motivations, this is a big deal, because if that's implied agency at that point, because they're telling me these different things and I'm learning, I have to tell all of that to my client at this point. And so it is unfair. So immediately I have to give this form out. And so one of the disclosures, it says this, it says, such confidential information would include, but is not limited to, a party's motivation and financial qualifications. And so you would give this to a seller that is a FSBO, right? So you're representing the buyer. So you're going to give it to the seller because the seller needs to know that you're not representing them. You would give it to the landlord, the buyer, or the tenant. This is where this form would come in. You don't give this to a seller unless it's a FSBO, because that's an unrepresented party, right? You see this, you're not giving this to a represented party at this point. This is to someone when you represent one side of the transaction, because this form is, I can't represent you, and this is why. And keep in mind that if they're already represented, they're not looking for you for representation. That's why it doesn't say the seller on here. It is the FSBO, who is an unrepresented party, a for sale by owner. Cool. So then as we go through, it says, how is agency terminated? So performance is the most common one. Like, I found you the house. I sold you the house. That would be performance. Mutual agreement. We're both like, you know what? Let's get rid of this contract. It's obviously not the right time for you. It's not the right time for me. Like, it's costing me a lot of time and energy. Let's let each other out. Abandoned, right? Like, maybe you told your client that you were going to do all these different things, right, in your additional provisions in your contract. And it's like, I'm going to host an open house for you every weekend. And then you don't. That's abandonment, right? Like, you abandon what you told your client you would do. Expiration of terms, right? We know that we have 365 days, the max. And so if we write a contract at 365 days or sooner, at the end of that date, the contract is terminated. Death, right? If either party will terminate the agency, right? And so this is the thing. Who's the party to the agency? It's the brokerage and the client. So if you die, you're a designated broker, right? So that doesn't mean that the agency agreement's over. It still carries on with the brokerage. The brokerage will find someone to help them. This is between all of these contracts. We have to keep in mind that these are contracts between the brokerage and the client. These are not between the client and the agent, because the agent's a designated broker. Change in law, like if it goes to where it's illegal to sell the house, destruction of the property, if the property is condemned, bankruptcy of the brokerage or the client, and if the broker loses their real estate license. So then it goes through here. It says, which of the following would terminate a listing agreement? Death of the listing agent, the bankruptcy of the listing agreement, or the listing agent, death of the seller, all the above. Which one?
I would say C.
It's C, right? So the listing agent, the relationship is not with the agent, it's with the brokerage. The bankruptcy of the listing agent, it's not with the listing agent, it's with the brokerage. It would be the death of the seller. If the seller died, there is no contract anymore. So we have to keep in that mind, because that's a very real question that you guys could see. And you could see that, like, I even moved it around because the way that I saw it, it was flipped. And I'm like, you know what? They're going to pick the right answer if I leave it this way. So I moved it around a little bit, and we immediately went like, oh, the death, like a death, obviously. And we picked the first answer that we saw. Read the question, reread the question as we're going through. So the majority of your test is going to be around contracts. And this is what it is. It says general knowledge of contracts, the validity, the factors, void, voidable, unenforceable, rights and obligations, breach of contract, termination, bilateral versus unilateral, contract clauses, amendments, addendas, offers to the purchase agreements, general requirements, contingencies, time is of the essence, counteroffers, multiple offers. This is what they're going to expect you to know. This is the meat of the test. This is 17% of your test.
Hey, Charles.
Yes.
So was that last question D?
The last question was C, the death of the seller.
Okay.
So my first tip for everyone that I put on there is, remember, the OR gives to the EE. Okay? The OR is the giver and the EE is the receiver. So whenever you see that, anytime there's an OR, they are giving, the grantor, right? Like, this is the person giving, the beneficiary, right? Like, these are the people receiving. So let's jump into it. A contract is an oral or written agreement to either do or not do something, right? That's a contract. It could be either I'm supposed to do this or I'm not going to do this. An oral contract is valid. However, it must be in writing to be enforceable. All right? And because the statute of frauds determines the documents that must be in writing to be enforceable, and if we are going to change anything that is in one of these written contracts, we also must have it in writing, right? The statute of frauds says for it to be enforceable, it must be in writing. And for us to change anything that we have in writing also must be in writing. That is the statute of frauds. And to have a valid contract, we have to have capable parties, a lawful object, consideration, someone offering, and someone accepting. The offerer is the party giving the offer, and the offeree is the party receiving the offer. And we say it's usually the buyer is the offerer, and the seller is the offeree, right? While the seller is putting the home on the MLS and saying, hey, give me offers, right? That's what this is like, give me offers. It's just marketing. They're not offering the contract. The buyer's offering, hey, this is how much I would pay for your house. These are the things that I would do to buy your house. And then the seller is receiving. They're the offeree. A valid contract is one that meets the basic elements of contract law. So it has to hit all of these pieces, and it must have capable parties, lawful object, consideration, offer, and acceptance. A voidable contract is when the contract enters under duress, misrepresentation, it's voidable, right? Like, this is the thing. If I go through and I were to put a gun to someone's head and I would say, I want you to sell your house to me, that doesn't make the contract void. Because once they do want to sell it, like once I gave them good terms, right? Like I didn't like lowball them. I was just like, you're going to sell me this house. And they're just like, I mean, they might have been in duress and they were scared at the time, but they're like, you know what? Charles actually gave me a reasonable offer. I want to accept this. Doesn't make it void. It's just voidable. But if they were just like, no, those terms sucked. Charles had a gun to my head. Now it's void. Okay? So that's the difference, right? Just because there was duress or something happening doesn't mean it's a void contract. It just means it's voidable. Because maybe the situation, I didn't like the situation, but the terms were favorable, so I'm going to take them. A void contract is it's missing one of these pieces, right? Like maybe it wasn't accepted, there wasn't a lawful object, there's something in the contract that was missing, and now the contract is void. We have an executed contract is when all parties have fulfilled their promises, and an executory contract is this, there's some things that still need to be done, some performance pieces that still need to happen. So here's one piece that we need to make sure that we understand. We go through. A breach of contract is a violation of the terms of a legal agreement, which is a default. A breach of contract allows the non-breaching party to either rescind the contract, they can sue for damages, or they could sue for performance of the contract. So the party that's not in default, the party that did not breach the contract, has these three things that they can do. They can either take their contract back and they're like, cool, I don't want to sell, I don't want to buy. Both parties are in neutral now. They can sue and say, hey, you cost me money, and they can sue for that money. Maybe it's the earnest money. Or they can sue for performance, which means like, I'm going to sue you to sell the house and go through with the contract. Like we have things to do, we're going to do specific performance. So liquidated damages is a provision that allows the parties a specific sum. And typically this is like that earnest money piece, right? Like the seller takes the earnest money. We have specific performance, which is where one party sues the other party. This is this is always on the seller. The seller always has specific performance to where like the seller's like, you know what? I don't want to sell this house anymore. My grandbabies were born in here. I got so many memories and I'm backing out. Well, the buyer can actually sue them to go through with the contract as long as the buyer's not in default anywhere. Now, typically what happens in that kind of situation is like the seller's like, you know, the house doesn't appraise, and the seller's like, well, I'm not lowering the price. Or the inspection objection comes through and the seller's like, I'm not fixing any of these items. Take it as is, right? And so that's where that's like their only remedy to kind of scare the buyer off. But the buyer's like, okay, cool, I'll come up with the extra 10K. All right, we'll fix that a little bit later. That's where if the seller still backs away so far, the buyer would sue them. Rescission is a remedy that declares the contract invalid and returns both parties to neutral. In the nation, right, we have what's called the Electronic Signature and Global and National Commerce Act, which basically means this. Pretty much all of our documents and contracts can be digital. They don't need to be wet signatures anymore. We can go through and we can have a contract that goes out to one party and they can sign it digitally and the other party can sign it digitally, and then it's a full contract. Okay, so that can be documents and contracts. A bilateral contract is where both parties have to perform, contract to buy sell, right? The buyer has to go through and do all their pieces and give the money, and the seller has to go through, do all their pieces and give the title, right? Like that's a bilateral contract. Two parties must perform. Unilateral contract is where only one party has to perform. And so when we're going through here, think of an option. Okay, that's the second one, is an option contract. And that's when the seller's like, hey, or the buyer comes up to this person and says, hey, I would like to buy your house. This house isn't on the market. This is probably a friend. And they were like, you know, I wasn't thinking about selling it, but you know what? I would sell it to you, and here are my terms. And I'll give you X amount of days to come and get the money. Well, the buyer never has to go find the money, ever. They have no obligation to perform. The seller, on the other hand, has to. The seller has to wait the days for the buyer to come up with the money before they can do anything with the property, or else they would be in breach of the contract. And it says, when the contract exists, we add something new to the terms, that's going to be called an addendum. So anytime that we add extra terms to a pre-existing contract, that's an addendum. And when we amend or have an amendment to a contract, that's where we're changing or modifying the existing terms, like a date and deadline, right? We might be changing the date and deadline. And then a clause. A clause is just a separate section of writing. So we have a clause that might be like, the house must be in broom swept condition. That would be a clause. It's not a part of the contract. So it's not something that's in the contract that we're changing. So this is just a separate piece of writing that is in a section. And then a couple more things for contracts. 17%, like this is a lot, and this is everything that you guys are going to be facing on here. An acceleration clause, right? So here's a couple different clauses. In a mortgage or trust deed, right, if the borrower defaults under the terms of the contract, then the entirety of the dollars due are due immediately. It's accelerated. Due on sale clause. This is where the seller sells their home and they get all that money. Well, all that money might not be theirs. They might owe a mortgage still. They might have a mortgage on the home and they owe the bank $200K. So as soon as that house sells, they are obligated to pay the bank their money. A release clause is something where like there is a bunch of houses in a development being built, and so the bank has 50,000 on all these different houses. Well, once one of the houses sells, some of the money goes back to the bank out of the entirety of this development, and what happens is that home is released from its lien from the bank at that point. So now all the other homes are now on the hook, but not that one. Subordination clause effectively makes the current claim senior to any existing claims. A contingency, right, is just what we're going to see. And you're going to see contingency a lot on the test. And those are your dates and deadlines. And it's like, listen, like I want to buy your house, but when I'm investigating this, something might pop up and we're going to open up some dialogue potentially around it. So I want to buy your house dependent on the inspection, dependent on me being able to get a mortgage, dependent on the lead-based paint. Those would be a contingency. And then time of the essence means this. We have specific dates and deadlines, and those are hard. Like if it says it is due today at 5 p.m., then it's due today at 5 p.m. Like we are all trying to get it done by here. And if one of us fails this, you're in breach of contract.
No, if you see another contingency, is that similar to I'll buy your house, but first I gotta sell mine?
That's a contingency, yes. All right, so then the next piece of the test is going to be around the practice of real estate, right? And this is 13% of your test. This is where we're going to go through trust and escrow accounts, federal fair housing, and advertising, licensee responsibilities, and antitrust laws. So as we're going through this, a couple things that you're going to see, right, is they're going to talk about commingling, right? Like the commingling of funds, which we know is a huge no-no. And that's where we're taking clients' funds and we're mixing them with ours, right? Or we have conversion. And conversion is maybe when we take one client's funds and we use it for another client, right? So maybe I am a property manager and 123 Main Street's plumbing just burst and they don't have any money in the account. But this other property has money in the account. I take that money to fix this property, even though I plan on paying it back. Like it was an emergency, I needed to do it. That's conversion. It's against the law. A real estate trust account is a separate account segregated from the broker's funds, into which the broker deposits all funds entrusted to the agent by the principal. So we have a trust account which holds clients' funds in it. Okay, this isn't our operating account. This is an account for our client. Then we have the Fair Housing Act, which prohibits discrimination of housing based off of race, color, national origin, religion, sex, familial status, or disability. The act exempts owner-occupied building with no more than 4 units, single-family houses sold or rented by the owner without the use of an agent, and housing operated by a religious organization and private clubs that limit occupancy to members. Okay? So what that statement says is like those are the people that don't have to follow the rules. At the end of the day, and this is what I would mean by this, like, let's say that I am, well, let's go what it really is, right? So let's say that I'm not an agent and that I'm renting out my house and I have a room for rent, and maybe I'm not comfortable having a female rent my room, and I only want other males in the house with me. I am allowed to say, you know what, no, I can't rent you this house because I would not be comfortable with you in here. That's what this would look like. So they are exempt when it is along those standards. Redlining, right? This is discrimination around mortgages. This happens when a lending institute determines that for various reasons, they're no longer going to make a loan in a particular area, right? This could be figurative or literal, and they're circling this neighborhood and they're like, you know what? This type of person lives in this neighborhood. It is not a good investment for us anymore. And so we will not loan to anyone looking to buy in this neighborhood. Steering, guys, and this is the thing, I think steering is a very easy thing to happen, right? Because this is something that we might go through and there might be a very valid reason. We're just like, I'm not comfortable in this neighborhood. I feel like this neighborhood's dangerous. You shouldn't live here. That's steering. That's against the law, right? Like you might get an uncomfortable feeling as you're going to show this property. And it's against the law for you to voice this and steer them out of that area.
And the kids fight.
Yeah. Right, and this is very true. Like I've had this experience where I've gone and shown properties to like single females, and where I'm a little bit uncomfortable walking around, and I'm like, and I want to be like, are you sure you want to live here? And it's like, you can't say that. That would be steering. If they ask you for the advice, like some of the things that I've been doing is like, if someone says like, Charles, what do you think of this neighborhood? Do you think this is safe? Whatever. I'd be like, you know what I would do? I would just drive it at night and just make sure it's the same neighborhood at night. Right? Like, and that's one of the things. Like, and guess what? You guys are going to be in these situations where you are showing properties at night and you are going into these very dimly lit. Be very careful, guys. Like, this is very serious, and while we can't steer people out of here, there's going to be times where your mind's going. Like, it will happen. Blockbusting. This is panic selling. Okay, so they're going to call it either blockbusting or panic selling on the test. And the reason why this is illegal is because the agent's the one that benefits from this, right? Where they're really going through and they're like, hey, you know what? You need to sell this house. This type of person's about to move in, and the property values are going to go down. Sell now before anyone else hears that. And guess what? The real estate agent's the only one benefiting, right? Because now they're getting to sell the house. They don't care who the buyer is at that point. They're selling the house. They're making a commission, and if the other person's buying, they're going to make a commission there as well. So all three of these are illegal, and blockbusting they'll also call panic selling on the test. And then we have the American with Disabilities Act. And this was signed into law, and this just makes it illegal for you to discriminate with anyone with a disability, right? And this could be a mental or physical impairment, but it's the ADA. So then we go through and we say HUD. HUD provides fairly specific information on the language that is acceptable in advertising. So what we can't use are any code words, catchphrases, color, familiar status, handicap, national origin, race, religion, sex, or gender. Or we can't add photos, drawings, or symbols that might imply something, like throwing a cross on, or saying perfect for your family, and it's just this Caucasian family, right? And like they're in front of a church maybe, and like all these different things. Like this is the thing where we talk about like the unconscious bias, right? To where we might not be thinking that we're doing it, and someone might think that we're doing it because like if all of our literature and all of it's the same and we're constantly pushing this out and it's like it's the same kind of family always over and over, that can be looked at as discrimination. So as we're going through, it says all advertising on residential real estate for sale, rent, or financing should contain an equal housing opportunity logo, statement, or slogan as means of educating that the home-seeking public that this is available to anyone, right? We're not going to discriminate. This is equal housing opportunity. All are welcome. An ad placement during December that reads, "Give yourself a Christmas present with a new house" would be permitted. Or would not be permitted, I'm sorry. Would not be permitted, right? So if we're going
Would
through,
not be prohibited.
or not be prohibited, I'm sorry. Not be prohibited, because this is the reason why. Christmas isn't really looked at as like a Christian holiday anymore. Like it is and it isn't. And people go through and we have like the Christmas to remember, right? Like Lexus and everything like that. Like Christmas has lost a lot of the religious factors behind it. And there are some people that might be considered Christian but aren't like practicing Christian. Like they're not going to church, they're not doing all these things, but they celebrate giving gifts. So something like this would be okay because the pieces have kind of fallen. Same thing with like Easter, right? Like people go and they do like the Easter egg hunt. It has nothing to do with like, while we know what it's for, the kids and some of the people that celebrate it, they're going through and it's more so for what the activity is, not so much what the activity represents. So an office policy shall identify and provide adequate means and procedures for the maintenance and protection of confidential information, okay? So we actually have to have a way to protect confidential information when we get it. And it says a designated broker shall be permitted to reveal to their supervising broker, because of our contract, confidential information about our client. So who is ever supervising you through the transaction, you are allowed to give them confidential information about your client because it's also in the contract and it says you will. We have a do not call registry, right? And this is designated to allow consumers to get off of those calls, which really I think just protects them from small businesses and real estate agents, because I can't tell you how many calls I get a day that are robo-dials and they don't ever go away. But that's what the do not call registry is. You have to know the difference between an independent contractor and an employee. And I would say the biggest thing is that an employee, you have your hours dictated to you and you have taxes taken out of your check. An independent contractor, you make up your own hours and you're responsible truly quarterly to pay your taxes, right? So on your test, it might give you the description of like you have to monitor your own taxes and you can't be dictated hours. Are you an independent contractor, employee, whatever? You're an independent contractor. We're going through, you have your Sherman antitrust laws, and these prohibit price fixing, group boycotting, the allocation of customers and markets, and tie-in arrangements. So price fixing. This is when you go through and you have multiple organizations saying like, hey, you know what? This is what we should do for the price because we own so much market share in this area. If all three of us were to be charging 8-10%, every consumer would have to pay us 8 to 10% because all of us are doing it. When we go through and we have group boycotting, that's where we're just like, you know what, we aren't going to use X company. And there's one of these going on in the industry right now. There's a big lawsuit happening with a company to where they have stated that there are brokerages out there that told their clients not to use this company. And there is a giant lawsuit going on right now because supposedly brokerages said we should not do anything with these people. And so they got boycotted, like an entire brokerage did. Then when we go through, it says a builder wants to buy the land, but the broker refuses to sell unless the builder agrees to list the property. This is a tie-in arrangement. And then allocation of markets to customers. This is when we're going through and it's either location or customers, and we're like, you can work with this type of customer because they're like you. You can work with this type of customer because they're like you, and or this place can, or this brokerage can have this territory because that's where most of their clients are, and vice versa. So while a brokerage can, like, I think of this as like property management, this might be real, right? To where the property management company says, you can have this territory, that's where you're managing. You can have this territory, this is where you're managing. And they're not basing it off of these criterias. But that's what this is where they're saying, hey, like KW, you can have over here. Remax, you can have over here, right? That's illegal. So these are illegal because of the Sherman antitrust laws that are in effect. Cool. So then valuation and market analysis, 7%. So appraisals, estimating values, and competitive versus comparative market analysis. So as we're going through, it says this, an appraisal. We have economic factors, environmental factors, physical factors, and social factors, which affect the opinion of the appraiser who's doing the appraisal. Buyers of real estate can hire an appraiser to determine the fairness of the asking price, right? Known as market value. And so market value is truly what we're going through, and it's an arm's length transaction. It's saying, yeah, you know what? You might have said that you would pay $1 million for this property, but based off of everything else and what everyone else is buying, this home is probably only worth $800,000 because what the market is saying it's worth. It says, when the government seizes privately owned real estate through eminent domain, we have to have an appraisal done to figure out fair market value. If the lender wants to make sure that the home is worth what the client wants to buy the home for, they get an appraisal. When we're going through, it says all property value is created through anticipation, which means like how much the property will be worth at a later time. Competition describes the fact in real estate where it's the supply side versus the demand side, right? And as we know that we have had very low supply nationwide, and so the demand has been so high. That's why we've had such high prices on homes so far, and we're seeing it shift a little bit right now. Conformity is the values created and sustained where real estate characteristics are the similar. That's conformity. Contribution means a building is worth the value that the market places on it. The principle of highest and best use states that every property has a single and highest and best use. And substitution just means that we as society, if the houses are apples for apples, we are choosing the cheapest one. And then when we go through, we have the sales comparison approach, right? We're just using comparables in the area. We have the cost approach, which means that we are going through and we're figuring out how much it would cost to recreate this. We have the income approach, which just goes through and it says that based off the dollars that this thing's bringing in, this is how much the property is valued at. So your sales comparison approach, this is like your CMA, this is for residential real estate. Your cost approach, I think of like a church, right? There aren't a bunch of churches in the area, so we're just going to figure out what it would take to rebuild this church. The income approach, think of a strip mall. And then we have comps, which is short for comparables. And what happens is we go through and we figure out what the different homes are valued at. And that is going to give us our comps for the area. Our subject is the property we're trying to figure out the value of. And the comparables are the properties that we are determining the value for the subject. So here's an example of a question. It says a subject property has a pool, but the comparable property does not. If the pool is valued at $3,000, what adjustment should be made?
Yeah, see,
Why is it saying that?
because the subject has the
Oh, because
pool.
you're,
So you're
Okay.
trying to get to the comparable.
Yep. Add 3,000. Yep. So this is the thing, guys. We always add or subtract from the comparable. Always. We never touch the subject. And so if the subject's value is more because it has a pool valued at $3,000, we actually have to add $3,000 to the comparable. So let's say that the comparable sold for $500,000, right? Because that's where we get comparables from. It's houses that were on the MLS, they sold. So the house is worth $500,000. And our houses are apples to apples, except for we have a pool. So now that home, our home is probably worth $503,000 because we added $3,000 to the 500, and now our home is worth 503. That's what we're putting on the MLS for. Cool.
I get it wrong by 3,000.
Do what?
National and then the ultimate.
How do you get that? I think that there's just some things, right? There is no real math to this, right? And so I've heard like bathrooms worth $5,000, bedrooms might be worth $10,000, right? The garage is worth $10K, a carport's worth $5K, right? Like you're just going to go through and you're going to have a dollar in your head. And keep in mind that this is, for us, this is a CMA. This is just what we're going to put it on for marketing purposes. And if we say that, you know, if we were to add 5K here, subtract 7K here, AC different pieces, we're just seeing like what's going to get the most attention for a house. So while we teach an appraisal class taught by an appraiser, I've seen like 3, 5, 7 different ways to do this. There's no wrong answer. So then real estate calculations, 10%. You have to know basic math concepts, your LTV, discount points, equity, down payments, and then calculations for transactions, property tax calculations, prorations, commissions and commission splits, seller proceeds, buyer funds, PITI, all the fun stuff. This is 10%, 80 questions, 8. You're going to have 8 math questions. And so, as we're going through, LTV, here it is a ratio of a mortgage loan principal to the property's appraised value or its sales price, whichever is lower. So keep in mind when they're trying to figure out the LTV, the bank is only going to loan to the lower amount. So it says, for example, if a borrower obtains $80,000 for a loan of a $100,000 property, the LTV would be 80%. We're getting 80% of the value of the home loaned to us. Discount points. Discount points decrease our interest, okay? And it's based off of what the bank is loaning us, not the purchase price. So I think you could see this one of two different ways. You can either see it as the bank is loaning you 80%, right? And so you would go through here and you would figure out what 80% of the purchase price is and then figure out 80% times the points, and that's what it's going to give you. Or it could say that the bank is just straight loaning you X amount of dollars off of a purchase price. So they might have, so what I'm trying to say is this, they might just give you the math, right? To where they're saying, here's the purchase price, the bank's loaning you this, what are the points, right? Like you take the points and you figure out what the dollar is. Or they might say the home value is X, the bank is loaning you Y, percentage-wise, and depending on what the points are, how much money do you need to bring to the table, right? And you already brought X amount of dollars in earnest money. Like they might throw a bunch of different pieces at you, right? To where you're having to bring, you have $6,000 in earnest money, well, that's going to subtract from how much money you need to actually bring to the table.
You posted a video about this.
I posted a video about this. Yes, check out the page there. It's there, where I run through both of them, I believe. Then we have equity, guys. Equity is just the difference between what we're either purchasing the price for versus the down payment, or the appreciation of the home, right? So if I have bought a $500,000 house and I had to bring down $20,000 in down payment, I have $20,000 in equity. Or if I bought the house for $400,000 and now the home's appreciated to $500,000. I have $100,000 in equity. So either one of those would be equitable interest. Down payment, right? So you're gonna have to figure out what down payment is, where they're saying the purchase price is $300K, you have to bring down 10%. So then you're just doing 300 times 10%. Like, that's simple, right? Like, these are pretty simple. So don't get scared of these. For calculating interest on a home, don't get caught up in the 30 years, the 15 years, any of that stuff, okay? If they're saying that if the home loan is $300,000 and you have to pay 8% in interest, that's your interest amount. I don't care what year it is. For the most part, they're not going to have you do any amortizations or anything like that. It's just going to be straight line. So if you go 300,000 times 8%, that's going to give you your interest. Okay. Your transfer fee or tax. So they might say something like 50 cents for every $500. And this means that the buyer or seller would have to pay 50 cents for every $500 increment of the price. So if it was a $200,000 property, and you would take 50 cents divided by 200 times, or divided by 500, and then multiply that by 200,000, which would equal, there's a $200 transfer tax, right? So for every $500, we have to pay 50 cents, and on a $200,000 home, that's a $200 transfer tax. Then we're going through, and it's saying that you're a broker who sells a house. The owner agreed to pay you 5% commission. How much would you earn in the house? Cool, that one's simple, right? Or they might do a split on you, right? To where they're going through and it's saying $20,000 commission on a 60-40 split. You guys are the front, always. The broker is the front number. The brokerage is the second number, always, okay? So they're asking you what you're gonna receive. You are the front number every time, not the back number. The back number is always the brokerage. So then you're just going through and you're taking 20,000, and then you're gonna multiply that by your split, which is the 60%, and then you're gonna get your commission amount, all right? Your big one, prorations, right? Like, and so, don't worry about this, but what I did see is I've had a lot of people call me last week and they were like, Charles, help me break down this question. And it was always around statutory year. I got like 2 or 3 calls this week about statutory year. And a statutory year is just a 360-day calendar. And this is the thing, if you screw up and you put 365, it will be a big deal, okay? So I need you to know that the statutory calendar is 360 days, and it is a 30-day month every time. So every month is treated as 30 days, even February, which we all know is 28 days. So while I think that you can screw up by a day or 2 on the calendar, on a 365-day calendar, if you're trying to do this math equation on a statutory year and you're basing off of 365 days, you will be so far off. It will be astronomical to where you won't even be able to guess. So, yep, and so statutory year, this would be on national, right, because we operate on 365 here in Colorado. So this would be a national question if you got a proration, which I'm not saying you will or you won't. Who knows? You will see prorations on the state. But on the national piece, you may or you may not. And just know statutory year, 360, 30-day month as you're going through. Who owns the day of closing is going to be important. Are we basing it off of a 1 month, a 1 quarter, a year? You're going to need to know that. So make sure you're paying attention to that. And who has already paid? Like, was this already paid in the front? Or is it going to be paid in the rears? And so depending on if it was paid in advance, then the seller's going to get credited. And if it's paid in the rears, the seller's always going to get debited. Like, always. Like, that's how it will always work, right? If we're on the buyer's time and it's paid in arrears, the seller's got to pay. And if it was paid in advance, then the buyer's got to pay, right? Like, that's just how this thing works. So you pay for the time that you use, right? Real estate calculations, guys, this is the thing. Like, I know that most of this is pretty simple as we're going through. We have our part, our total, and our rate. And as we're going through this, I think a lot of the ones that might be a little bit harder is probably like example 3, right? ABC receives a $10,000 in commission, and the commission rate was 10%. What was the purchase price, right? So that's when we actually have to take the 10,000, and that's the part, right? And then we have to divide it by the rate to figure out the total. Like, I think that's probably going to be the most confusing one out of all 3 of them. Go ahead. But like the rest of them are simple, right? Like if I were to give you a $100,000 house and you're getting 10%, right? Like that's just straight across. Like we understand that one. I think that number 3 example is a lot harder to comprehend as we're going through. When I'm getting 2 smaller numbers, I need to figure out the bigger number, and it's just counterintuitive to divide, I think, a lot of the times.
Hey, Charles,
Yes.
before we went into this, did you say if the buyer pays in arrears? Or can you repeat that? You were just going to reparations, but you said who pays in arrears and the seller pays. And can you repeat that one more time?
Yeah, absolutely. So this is the thing. We're always paying for the time that we used it. Like, so it's only fair that if you used it, you pay. And always, if it's paid in the arrears, you're going to debit the seller. Always. Right? Because it means it hasn't been paid. It's going to be paid in the future. And so the seller hasn't paid for it, and we need to get the seller's money. And if it's paid in advance, and now the buyer's getting to benefit for time that the seller paid for, the buyer is going to get debited, right? So if whatever party is benefiting from the time, they have to pay for that time. So if it's paid later on down the road, we got to get some money from the seller to pay for the time that they actually used. If it's paid all in the beginning, then we have to give the seller some money because they paid for time that they're not using. This isn't like a like one of those what are those things called that you, when you drive into downtown Denver and you put money in the machine for parking? A meter. Yeah, this isn't a meter, right? Or you just leave it and someone else gets a benefit. You pay for the time that you use.
Thank you.
You're welcome. Cool, guys. That is it. That is the national piece. Like, as we're going through this, I think that while we just threw a lot at you in an hour and a half, I think that most of you felt pretty good about everything. And like I said, we didn't touch like 6 chapters, right? So let's just say that we bombed the math. If you had a fairly good working knowledge around the pieces that we did see, right? Like as we go through this, if you had good working knowledge around everything but the math, and you were able to piecemeal, transfer a title and property disclosures, don't worry about the math, right? Like that's what I'm saying. Like the math is there, and I know that you guys are at least be able to get half of them, right? Like you're going to be able to do commission rates. You're going to be able to do the loan to value because that's just a percentage off of the purchase price. Like those are simple. So don't get caught up in the proration piece, right? Don't get scared about that. So I think you guys have this.